Good morning and welcome to this session of the Florida Supreme Court. The first case on today's docket is the State of Florida versus Garcia. Counsel?
Mr. Chief Justice, good morning, and may it please the Court. Assad Ali, Assistant Attorney General, on behalf of Petitioner, the State of Florida. The Third District erred in determining...
Could you speak up just a little bit? I don't know if the marshal could do something to adjust the volume here. It's not really working very well.
Yes, Your Honor.
That's better.
Your Honor, the Third District erred in determining that respondents' convictions for second-degree murder and second-degree grand theft were legally insufficient and reversing the jury's verdict. The evidence adduced in support of both convictions was sufficient under the older discontinued circumstantial evidence standard, and importantly, under the current competent substantial evidence standard that is applicable to all criminal cases and for which Garcia's convictions must now be reviewed under. As far as the homicide conviction, the state's circumstantial evidence, when viewed in totality, was sufficient to establish each of the elements. The concern the Third District had on appeal in reversing the jury's verdict and reversing that homicide conviction was this impermissible stacking of inferences. I'd like to make 2 points as to that principle. One, I think in this case, the circumstantial evidence didn't amount to what's been called the stacking of inferences. We have a collection of a variety of circumstantial evidence that are related. But
let me ask you about one aspect of the evidence. Doesn't the evidence show that Mr. Garcia lied in his description of what he did and didn't do in certain respects?
Correct, Your Honor.
Now, in our case law, isn't the circumstance that an accused has lied about what went on and what did not go on frequently used as a basis for discrediting the accused overall version of what transpired?
That's correct, Judge.
Okay.
We have that in this case, and we don't view each of these circumstantial evidence pieces in a vacuum. We don't view them in isolation. So not only do we have the inconsistent statements, we have cell phone pings, we have DNA evidence that was recovered from the victim's car after it had been thoroughly cleaned. We have the financial transactions that he obtained from the victim immediately after her disappearance. We have the nature of those transactions, the irregular circumstances in which they occurred, obtaining money through a check, obtaining money through an ATM withdrawal, obtaining money through a online transfer, all on the day after she disappeared. So combining these inferences, the circumstantial evidence does not amount to inference stacking. It's putting pieces of a puzzle together. I think in light of this court's decision in Bush v. State, I think this court made clear that circumstantial evidence should not be treated as a sort of second-class category of evidence that, it's just as relevant, it's just as reliable in so many respects as direct evidence. And I think what really animated the Third's decision below was this prohibition, what some district courts have said, amounts to inference stacking or bootstrapping or pyramiding of inferences. I think in light of the Bush decision, I know this court has previously said that pyramid stacking is inextricably intertwined, with this circumstantial evidence test that's now defunct. I think that in light of the Bush decision, the impermissible inference stacking does not survive. I think one of the chief concerns of the circumstantial evidence standard of review was to prevent convictions based on mere speculation. And I know that this court said that standard jury instruction, which compels a jury to only convict if they find the state's proved its met its burden of proving beyond a reasonable doubt, protects against that. In the same respect, the jury instruction, the requirement that a jury could only convict someone of an offense if the state had met its burden, also protects against obtaining a conviction based on mere suspicion.
Counsel, could I hear the state's position? Argument that to the extent that we have doubts about the strength of a particular piece of circumstantial evidence, that our doubt goes to weight as opposed to admissibility, and that the federal rules of evidence, by contrast, have long sort of had this settled distinction between the weight you give a piece of evidence, whether it's circumstantial or not, being completely bifurcated from whether it is direct or circumstantial?
I think as far as when a reviewing court, and particularly in this jurisdiction, when it views the circumstantial evidence, it doesn't view it in isolation. I also think it's not the role of a reviewing court when making determinations of sufficiency of evidence to get into weighing the evidence. I think this court asks whether the evidence was sufficient. Could a reasonable trier of fact find all the elements of the offense beyond a reasonable doubt? And I think we maintain the perspective of viewing all reasonable inferences in favor of sustaining the jury's verdict.
Thank you.
When the state sought review in this case, Bush had not been decided, correct?
That's correct, Judge.
And so the argument, and actually when the jurisdictional briefing was completed, Bush had not been cited, correct?
Yes, Justice.
So the argument for jurisdiction was that the opinion below was inconsistent with our precedent under the old circumstantial evidence standard. Is that correct?
Yes, Your Honor.
Can you explain the basis for jurisdiction under that standard again? Well, actually, my question is more, it's clear that once Bush came out, that the opinion below is in conflict with Bush because they applied a different standard. Would it be appropriate to consider that as a basis for jurisdiction if I personally have questions about jurisdiction as it was argued originally in the briefing?
Justice Lawson, I think it would be appropriate to consider the Bush's decision in light of jurisdiction. The reason being is this case is pending direct review, all for the duration of the time that Bush was pending it. There was never in a stage of being final, so the fact that it was pending direct review, I think, another conflict jurisdiction issue arose in light of the Bush decision. We did initially petition for review based on the misapplication doctrine that the third DCA's decision misapplied this court's precedent interpreting the circumstantial evidence standard of review. But the fact that the decision has been pending for the duration of the time and Bush was issued, it's a pipeline case in that sense, and I think that another basis for conflict jurisdiction arose in light of that Bush decision.
Thank you.
The guard against impermissible inference sacking is inextricably intertwined with the circumstantial evidence test, and I think in light of the Bush decision that abandoned that standard of review, I think that the prohibition against inference sacking also has to go. That's it didn't occur in this case, and assuming it did, I don't think it's no longer valid in light of this court's decision in Bush v. State. And if there are no further questions, I'll reserve the rest of my time for rebuttal. Thank you.
My counsel correctly notes that you can never convict on mere speculations.
Counsel, I'm
And
sorry, I'm having trouble.
I'm sorry.
I'm having trouble hearing.
Is this better?
Yes, and
Thank you.
It may be my hearing, my deficient hearing.
I'm with you.
Okay.
Your Honors, the state doesn't have to exclude every reasonable hypothesis of innocence under Bush. We know that. But the state still has to present, and they always have to present, competent, substantial evidence for a jury to rationally conclude beyond a reasonable doubt that the defendant is guilty of the crimes the defendant is charged with. And however way you look at this case, from whatever direction, when you examine the sufficiency of the evidence, which is still available to do under Bush, in the light most favorable to the state, all you had is you had to guess at what happened to Larissa.
Well,
let
me walk through that with you, maybe according to the elements. So the first element is the victim is dead. And under Crane, I don't think you've ever argued that there wasn't sufficient evidence circumstantial evidence to show that she was dead under Crane in the test that we used. Is that correct?
Well, I mean, we certainly believe that the evidence, we don't concede that they proved she is dead. The third district said her apparent death based on the length of time of her disappearance.
So, under Crane, when no body is recovered, to survive a JOA, the state must present evidence of an abrupt and sudden change of the victim's behavior, habits, and plans. And I would add that that's just, I mean, it's every case is different, but that is so out of the ordinary given those habits that you can conclude based on that alone that the victim is dead. Is that correct? That is the law in Florida.
That is the law in Florida. And in this, I'm sorry, I didn't mean to interrupt.
And she had calling her family regularly, routines. She'd never done anything close to like this, and she just essentially disappeared.
And the jury, and the state, the third district said, and in this court.
Well, but I'm asking you, what is your argument that is not sufficient to allow a jury to come back?
That element,
with a verdict?
the evidence in that case, certainly there was countervailing, and there was for and against that element. They met the minimum threshold.
Okay.
And to demonstrate her apparent death.
So I'm going to summarize just for simplicity's sake, for argument. The last two elements really can be summarized as: did Mr. Garcia, is he responsible for her death?
And this is
Is that correct?
This is the nub of this case,
right,
and
okay.
I think we all agree. And it's that: is there sufficient competent evidence from which a jury could rationally conclude, beyond a reasonable doubt, that her apparent death was at the criminal agency of Mr. Garcia?
Would you agree that literally everything points to him? The DNA in the car, the fact it was scrubbed down, the fact that he ended up with all of her money by check, the cell phone information, he was with her cell phone. I mean, the video of him in the car at the ATM where he was withdrawing her funds after lying and saying he never drove her car. I mean, all of those circumstances, every piece of evidence points to him and him alone, correct?
I disagree respectfully, Your Honor.
Okay. Explain why.
They had a murder for money theory. Mm-hmm. That was their entire case, murder for money. And their own. I
mean, just to pause there and reflect that it was their entire case because he took all of her money, and we know that he did it. He ended up with all of her money, and we know he did it.
Their own evidence disproved their murder for money.
Okay.
Miss Butler, the FDLE examiner, said she probably wrote the two checks. The two checks dated, one was June 5th, one was June 10th. There was no evidence as to those online transactions, online transfers, as the third pointed out. So the state didn't prove a theft. That was the.
Well, let me just pause there. Would you agree that the evidence suggested that she signed those checks and that they were cashed by Mr. Garcia at a time when a juror could reasonably have presumed that she was dead? We just dealt with that first element.
We disagree because the only evidence that they say that the way this happened was that on June 4th, he killed her at his house and disposed of the body in her car. Okay, they say that because on June 4th, her old phone starts to the usage changes. They don't account for her new phone. They say that the house, the car, but all of the evidence, and they tried to prove that, but they didn't. And you only need to look at the forensic testimony in this case to see that every time they tested the car, it came out negative for blood. Detective Segovia, 3 months before trial, retested the car. He tore it apart. He had them go through the cushions because they thought, well, maybe the car was so clean that the evidence of blood, but they can't do that in the cushions. Came up nothing. Cadaver dog at the car, at his apartment, nothing. So every theory they posited as to how this
Now,
happened
just with respect,
fell apart on their own evidence.
Well, with respect to the blood, someone had thoroughly cleaned the car with bleach, correct?
Well, the testimony, that isn't, that's
okay,
not,
correct me if I'm
and
wrong. Yeah.
The testimony was that when the car was returned on June 10th, and when it was opened up on June 18th, it smelled like it had been cleaned. Well, no, it's sitting out in the summer sun in Miami, so however that is. But, the jury is certainly entitled to infer that the car had been cleaned, and who cleaned it, we don't know. When it was cleaned, we don't know. He was in possession of the car. They could have.
We do know that he was filmed
on June 5th,
driving the car.
On June 5th, he's seen in the car. So no question. But you don't have the. But I'm
let's
sorry.
just look at the car, for example. I mean, if not him, who else? Using the old standard, what's the reasonable hypothesis that it was anybody other than him?
The reasonable hypothesis is that the evidence shows that their theory that he killed her to steal her money is not true, because she wrote $40,000 worth of checks to him.
Well, but counsel, aren't you overlooking? I understand we have the expert testimony about the signatures. We also have this evidence that, if I recall correctly, was found in the defendant's home of someone having repetitively traced the signature of the victim and left an impression on paper from repetitively tracing a signature. Couldn't a jury make some inferences from that?
Well, if that had been the evidence, but respectfully, Justice Kennedy, it isn't the evidence, and I'm going to just move here.
Sure.
Katie Butler, just to clarify, the document to which you're referring is the original handwritten note by Larissa, undisputed by their own expert witness, in her own handwriting, the promissory note. They took the promissory note and they ran it through this electrostatic detection analysis thing that they do. And her testimony was that on page 820, I believe, that it did not indicate evidence of tracing. There was some imprints that suggested that there were documents that were on top of that promissory note that she may have been writing on, and then eventually she gets to that piece of paper, and it's like the old days when you were a kid and you would take a pencil and go over something. So it's that kind of thing. But again, it's inconclusive, and it's not really, doesn't even, that kind of evidence wouldn't come in a civil case.
Let me ask you this. Who gives a promissory note one day and then pays it the next day or within a short period thereafter? That's just it's just an extraordinarily improbable sequence. The timing on that for someone to give a promissory note and then to turn right around and write the checks.
Well, that's the thing about this case. There's more questions than answers. You have Larissa writing within 2 weeks before. She writes $7,000 worth of checks to another gentleman. We don't know why she's writing these checks and giving her money away. There's all manner of. And that's where I think where I'm at, and I actually still have some time, but is that what we're talking about here is
You're fine on your time. You've got
I see
about
that.
9 minutes left.
I know. I'm used to 10 minutes aside. But you have to guess at how this happened. And we've never allowed juries to just guess by, process of elimination, we don't have any forensic evidence.
Miss Lerner,
And
let's
if we
Miss
look-
Lerner, let's pause there, because I agree with you that you have to speculate about how she was killed, all the circumstances surrounding that. But we've already established that there was sufficient evidence that a jury could determine that she was dead, and there's no requirement that the state prove how someone did the crime. The only question is who, correct?
Well, who did it?
Yeah.
Yes, and in
So
this,
that speculation about how maybe he tortured her or put a gun to her head and had her write the checks and write the promissory note and do all that, I mean, that would be all speculation, but don't you have to speculate more to suggest that it was anybody else other than him? Isn't that a speculative doubt?
I think that it's certainly a reasonable doubt that we have to entertain. But even so, if you look at the missing person cases that are out there, and the ones that they don't cite a single one that is even remotely like this, and that's because they're not brought when there's no substantial evidence, and they shouldn't be. I mean, in the missing person cases that they do cite, Myers, confession, corroborating injuries. Even Crane, it's a small child who goes missing, and the child's DNA is found on the defendant's boxer shorts, and you've got gouge marks that he has from the fingernails of a small child. The Virginia missing persons case, there was a dog scent evidence tracked from the crime scene to the defendant's front door, and in Bush, there was just no guesswork there, because the jury knew that Bush was responsible. There was the solid evidence of criminal agency. The DNA is on the murder weapon, and his 5 bloody footprints match. The 5 bloody footprints match his favorite boots. And I think that's really what we're talking about. What is it in our jurisprudence, where are we going to draw the line? Are we going to allow a verdict to stand on what really is speculation in this case, when their whole murder for money theory collapses under their own evidence that she did write these checks? This is what she did. This was not out of character. We don't know why she gives money to other men, but she does, and she has. I think it's reasonable to infer that she has plenty of it beyond what she had in those bank accounts. And so we understand that this is, and the 3rd District said the same thing, awfully suspicious. But suspicion alone has never been enough to convict. And we're asking this court to affirm the 3rd District. If the court has any other questions, I'm happy to entertain them. Thank you for your time and attention.
Thank you, counsel. Rebuttal.
This court has reviewed the facts of this case at length, but just briefly, to touch on a couple of things Justice Lawson discussed. As far as these checks, these 2 checks in this promissory note, the jury didn't just hear this 2 lines of testimony from the FDLE examiner. We know that the FDLE examiner qualified her opinion as to the 2 checks. She said it's probably written by the victim, but I'm looking at machine copies of these checks, so there's some qualification there. As for the promissory note, as Chief Justice Kennedy pointed out, it was written the day before it was that respondent received the sum of the entire promissory note. It's completely unheard of for someone to write a promissory note for $20,000 and then the next day repay it. And there are significant other factors that come into play, pieces of evidence that show that there is something nefarious going on with these transfers of money. We know that there's no way possible for the respondent to have funded this amount. The state introduced bank statements from the past 4 or 5 years, and there was no significant deposits other than annual tax refunds. We know that there was no withdrawals from his amount matching the sum that he purportedly lent to the victim. We know from the interaction with his wife at the police station that There's just no way he could have funded this amount. There's no evidence that he was going to open up some sort of business or anything like that with the victim. There was just everything else refuted that. All the other evidence that the state adduced refuted that. So we don't just look at the FDLE examiner's 2 lines of testimony in isolation. The jury did not just hear that. Perhaps if they did, then maybe there would be some legitimacy to these transactions, but they heard a plethora of evidence that indicated there is no legitimate reason, no valid reason for a respondent to receive these funds. And I think the state established that pretty sufficiently. As far as the car, roughly a month after it was sitting in the sun, it still smelled of cleaning agents. That's the extent that it had been detailed and cleaned. There's only one person's presence who was found in that car. It was respondent. We know that he was seen driving the car the day after the victim disappeared, withdrawing money from her ATM account. And we know when he did that again a week later, the car had already been dropped off. In the footage from the second ATM transaction, he's not in the car because it's already been dropped off. He's seen standing alone. There's the only speculation that would occur here is if someone else was responsible for the victim's death in this case. There is no one else responsible. And I think what the third did is get into reweighing this evidence, which we know that reviewing courts do not do. It's not within the province of a reviewing court when making determinations of the legal sufficiency of evidence needed to sustain convictions. Applying, even under the old standard, the state submits that the evidence is sufficient, but under the applicable standard now, it certainly was. So we would ask this court to reverse. If there's no further questions from this court, we'd ask that they quash the decision below and